appeal in the matter of CDE by her mother and litigation friends and Surrey and Sussex Healthcare NHS Trust.
Thank you. Yes, Ms. Gunn.
No, please, your lordships and my lady. In this case, I appear for the claimant who's represented by her mother and litigation friend, and my learned friend, Mr. Sheldon, represents the Defendant NHS Trust. Can I say at the outset, when granting permission to appeal, Lord Justice Stuart Smith granted an anonymity order by way of a separate order.
Well, can I confirm that? That an anonymity order exists in this case, which means that no report of the proceedings are to identify the claimant or her family, and the case will proceed under the initials that it's been gazetted under, and our judgments will similarly follow that course.
I'm very much obliged, my lord. My lord, I have handed in, but I don't think it's reached, or may have reached your lordship's bench, a one-page summary of the order in which I'm proposing to take the submission.
Very helpful, thank you.
I hope that assists. It is, I hope, a very narrow point which I can take quite quickly with the assistance of this map of my submissions, as it were. I say at the outset that the claimant suffered catastrophic injuries around the time of her birth. That's not in dispute. She has severe quadriplegic cerebral palsy, and the best description of the complexities of her disabilities is in the report of Dr. Pike, which was the only paediatric neurology report before the court. He wasn't called to give evidence, but his report was placed before the learned judge, and your lordships and my lady will find it at S236 in the supplementary bundle, and I just would refer to that because it's a helpful summary, and it also is the starting point of the finding of the judge, which is central to our submissions, that every minute of damage makes a difference. So the supplementary bundle S236 is the report of Dr. Pike. It's behind tab 15 in the supplementary bundle, and he describes there, and it's relevant to the difference that minutes make in terms of the damage to babies suffering hypoxic ischemic events, that this claimant's damage, sadly, is at the very extreme end of damage. She has gross motor classification system, GMFCS level 5 disability in terms of mobility. She has, in effect, no independent mobility. She's gastrostomy fed. She requires suctioning and sometimes home oxygen. She has microcephaly, in that at birth her head circumference was on the 50th to 75th centile, and it's fallen to the 0.4th by 9 months, and global developmental delay and epilepsy. In terms of the cause of her injury, Dr. Pike summarised, and it is a brief summary and is at page 240, the last paragraph of his report in terms of causation, that the cause of damage, and it's not controversial that the cause of damage was a profound near total acute ischemic injury, but obviously the timing is what's controversial. But Dr. Pike at page 250 states that increasing duration of insult above 10 minutes will produce material but not divisible increases in damage and disability. the indivisibility is more prominent in children whose brain insult may have been modified by therapeutic hypothermia, and the claimant in this case was cooled, and that has made dividing total acute ischemic injuries even more difficult, and that's now, I think, well known. In terms of the judgment, even though the defendants conceded injury by certain times, the judge found, and I'll come to that, that every minute did make a difference and that it was indivisible. So central to the appeal that even 1 minute does make a difference, and that's the starting point for that is the report of Dr. Pike. It was accepted by the defendant that all the claimant's injury occurred through a short period of total acute hypoxic injury around the time of her birth, and that comes from the pleadings at C111, where in the defence it's admitted that delivery by 1753, which was the original allegation based on the expert's evidence, would have prevented any injury. Delivery by 1800 would have caused less damage, and no admission was made by the defendants as to the outcome between 1800 and 1808, which is the actual time of birth. But I refer to that because it's important, particularly in the current climate, where it's often argued that the claimant's injuries were not related to birth damage. There is no such allegation here. It's accepted that it is the events around the time of her birth that caused the injury. The timing that would have avoided all injury is in dispute, certainly in the pleadings. The timing of the damage was investigated at trial in some detail, and there was a difference between the claimant's neonatologist, Professor Mitchell, and the defendant's neonatologist, Dr. Horden, as to whether the total period of hypoxic ischemic injury was 25 minutes, as the claimant's expert suggested, or 20 minutes, as the defendant's expert suggested. The judge preferred the evidence of Professor Mitchell, but found as a fact that it was 23 to 24 minutes. One finds that in the judgment in Core Bundle 168.
Yes, we've obviously studied the judgment carefully. So if you're content to do it, we're content to take the reference without having to follow it. But if you want us to have a particular passage in front of us, we'll of course do that.
Thank you. I think it's important that I don't think it's controversial that the judge found 23 to 24 minutes rather than the 25 minutes the claimant had suggested or the 20 minutes the defendant had suggested, because that is relevant when we come to the pleadings and why the timings in the pleadings are not necessarily the timings that the judge found. But obviously on this appeal, I'm confined to the findings of the judge, which is why the minutes may have moved. And I know a complaint is made that I didn't plead it on these minutes, but these are the minutes that the judge has found, and those are the minutes that I have to work with before this court, and that your lordships and my lady have to work with in terms of, was the judge right that saving any time made no difference in terms of the timing of the bradycardia. And the crucial central finding is that it was 23 to 24 minutes, and the first 10 minutes is likely to have been undamaging, but thereafter the total damaging period was 13 to 14 minutes, and that was based on the judge finding the bradycardia commenced at 17:48 to 49, so we have a minute's leeway there. It's also perhaps important that the judge's finding that the total period was 23 to 24 minutes rather than 25 minutes was based on the fact that if it had been 25 minutes, the baby is likely to have died. And that's perhaps one example of how crucial each minute is in terms of the timing of total acute hypoxic incidents. So the judge found the bradycardia commenced at 1748 to 49, and the claimant was born at 1808, but the damaging hypoxic event didn't end until successful resuscitation at 1812. And perhaps I can just go to that because that is important, that the damaging period doesn't end with the birth of the baby, but continues afterwards. And the evidence of Professor Mitchell, which the judge accepted, was that the shorter the period of damaging bradycardia before delivery, the shorter the period of resuscitation afterwards, so that there is a double benefit in shortening the period before. If I can just go to that passage, it's at C166 in the judgment. Paragraph 254, the end of that paragraph, was Professor Mitchell's firm opinion that the shorter the duration of PHI, the lower the level of primary injury that would have been suffered by the baby. And then at 257, Professor Mitchell advised that if the PHI was of shorter duration than the period of resuscitation needed at birth, likewise would be shorter. Therefore, in effect, there is a double benefit in a reduced period of PHI. So even though I'm working with very short periods, it is important to take into account that finding, which the judge accepted, that a shorter period before would lead to a shorter period of resuscitation and an overall saving in minutes of total acute hypoxic insult. So that the judge accepted that evidence, and that's an important factor. The effect of shortening the period of damage is obviously crucial, because if we're working with very short periods, the judge's findings on that, which, as I understand it, there's no respondent's notice in relation to those findings being wrong, that every minute made a difference. At C169, paragraph 280, I found Professor Mitchell's explanation of the likely duration of the PHI more persuasive than Dr. Horton's. There was much of Miss Horton's evidence, which I accept as well. I consider she was a little too rigid over the material contribution issue. Seems to me, and I so find, that any reduction in the period of PHI would have reduced the primary injury in the claimant's brain neurons. And that is a finding which was repeated in the later judgment of the same judge in CNZ and Royal Bath Hospital's NHS Foundation Trust. We put that in the bundles just to illustrate that that is what the judge meant. It's in the authorities bundle at tab 14. It's in some ways a similar case, a very long judgment in that case. But at page 408, behind tab 14 of the authorities bundle, at paragraph 389. It's page 103 of Mr. Justice Ritchie's judgment in that case.
I'm sorry, Miss Gumbel, my apologies. Which page?
I'm sorry,
No, it's my
page
fault.
408 of the bundle
Thanks.
and 103 of the judgment. Paragraph 389. And this was a case that was heard shortly after the case with which the court's concerned today. As to the law in causation of injury, I find that for this cerebral palsy case caused by acute PHI before and just after birth, the material contribution test is not appropriate in relation to deciding the issue whether the breach caused brain damage, because all the experts in this case advised that on the balance of probabilities, every minute of acute PHI caused damage to the claimant's brain cells after the 10th minute. I consider that the but-for test is sufficient and is satisfied. As to the law of causation on proof of quantification, and in that case there was an argument about allocates of 5 minutes, but the judge reiterated in that case that every minute mattered, as it were, so that I only point to that as to substantiating what I say is my interpretation of paragraph 169, that any reduction in the period of PHI, if it were said that that isn't talking about whether 1 minute would, every minute is referred to.
This is your third point, is it? In your helpful map.
Yes, I've got to the effect of shortening the period of
Yes.
damage in terms of my
Well, I think we have that.
map,
Have that
as it were. And so that I say a saving as short as 1 minute would make a difference and can't be brushed over, as it were, in terms of the judge's findings. In terms of the findings of breach of duty, and it is important that this is a case in which the judge was very critical both of the midwife and of the registrar, not of course of the consultant who did life-saving action at the end, but that's what this appeal is about, is how much quicker could she have done life-saving work if the CTG had been running as it should have been. And the difficulty is the difficulty for us in this case, as is the difficulty in many cases, and the reason we referred to a case of Keith in the skeleton argument is that where a defendant hasn't put on a CTG trace, we've got no way of, it's very difficult for us to prove what it would have shown. But there is a very clear finding that a CTG should have been running very much earlier. And the criticisms are both of the midwife, C140 to 144 in the judgment, and in terms of the obstetrician, C145 to 149, and both of those employees of the NHS Trust were criticised both in the way they gave their evidence, the lack of notes, and when we come to the pleadings, very significant changes were made to the defendant's pleadings, because Dr. Eckerman had said he'd done a second examination, which it turned out he later said was the same one rewritten out. So they are, I would say, very stark findings of breach of duty, and that is relevant to the background, and we would say to the interpretation of the timings when the judges found them. It is relevant that where the missing information as to what would have been on the CTG trace is entirely the fault of the defendants, that the courts should look more benevolently on the claimant's evidence and more harshly on the defendants, because it is through the fault of the defendants that we don't have a CTG from which we could have said at that point delivery should have occurred. That's what the medical evidence struggles with. But what we do have is that the breaches were lack of competent care between 1650 and 1750, and that the mother should have been on the labour ward by 1710. That's paragraph 163 in the judgment. Being on the labour ward at 1710 would have resulted in a CTG being attached soon after that. And so the crucial issue on causation is what difference it would have made if a CTG had been running from about 1720, which is the time the judge found the mother should have been on the labour ward and had the CTG attached, and whether any minutes could thereby be saved. That's the crucial issue following from the very stark breaches of duty, and the breaches of duty involved not taking sufficient note of the mother's very extreme pain, and the judge made findings in the claimant's favour on every allegation and preferred all of the claimant's experts to the defendant's experts. So it is a case where there were clear breaches in not starting a CTG trace soon enough to be able to determine when the plight of the baby began to suffer from the mother's condition. But what the judge did find, and I'm coming now to the sequence of events, is that the bradycardia started at 1748 to 1749. That's at C170, in paragraph 288 in the judgment. And these timings are not perhaps set out, which is why I've tried to set them out in my summary, because they're not set out, and that's maybe part of the criticism of the judgment, is that the timings aren't set out chronologically. We have to search in the judgment for different paragraphs in which different timings are set out, because they are crucial. So the bradycardia starting at if I start from the sequence of events, and I hope all the paragraph numbers are there, that the mother should have arrived on the labour ward but didn't, is 1710 to 1720 in different parts of the judgment, and I've put both of the references there. 1710 is mentioned, or 1720, but certainly well ahead of 1750. 1720 to 1730, the CTG should have been started but was not. And again, I've put the paragraph numbers. I don't think I need to go to them. The bradycardia starting but not being recognised is the 1748 to 1749, which is the page, paragraph 288 at page 170, is a finding of fact that the total period is 23 to 24 minutes. It's paragraph 288. And what's important about that is that the 23 to 24 minutes takes us not to the birth at 1808, but to the resuscitation at 1812. The timing was, I think, 1811 and 30 seconds, and the judge ran, and because Professor Mitchell had said the stopwatch wouldn't necessarily be entirely accurate, it would be reasonable to say 1812, work backwards from 1812 to the bradycardia starting at 1748 to 9. When the mother arrives on the labour ward, instead of at 1710 or 20 getting settled, getting the CTG trace on, everyone taking stock of her condition, she arrives at 17:49 is the timing, which is paragraph 302, page 172, is where the judge finds that she arrived in real life. The emergency occurred just as mother was arriving on the labour ward at around 17:49 hours, as I so find. So his finding of fact on her arrival is 17:49. The finding of fact in terms of the consultant starts her ward round. We know that from the consultant statement, the midwife's statement, and the judge's finding is that the consultant is standing outside the labour room with midwife Bond writing up her notes, and we get that from page 151, paragraph 141, and a number of other paragraphs. I don't think it's in dispute, but
It's 297, isn't it, where he makes the finding of fact that Miss Nix was outside mother's room on the labour ward at 17:50.
it's paragraph 297, paragraph 6. The first place is paragraph 64, and that's actually a useful summary of his finding on those timings. But there are. So paragraph 64, Miss Nix was doing her routine ward round on the labour ward at about 17:50 hours, came to outside the room in which the mother had just previously been transferred. She was writing her notes in the corridor at 17:50. She heard what suspected was a fetal bradycardia, and so she and her team entered the room at 17:52.
Now that came from the first statement that Miss Nix provided. That was to the original investigation. And the judge comments, right up on the next page, that what she said in that statement is then replicated in the statement that she made for the trial. She made two statements for the trial, but the second really doesn't deal with this point.
What happened was that it wasn't thought that she would be needed to be called at all, but she was called because there was a dispute as to why at handover they weren't told about the extreme pain that the mother was suffering. But it also comes from her own oral evidence, because she was then called and confirmed that. And in one sense, the timings obviously are important because the judge has made findings in terms of the timings, but the sequence of events is also important. And what is important from the purposes of this appeal are that had the CTG been on, the judge has found that the bradycardia would have started by 17:48-9. So if the consultant is starting her ward round and writing up her notes, and we've attached to the skeleton argument the notes she was writing just to show it wasn't fleeting, she was standing there talking to the midwife, writing her note. She then hears the bradycardia and goes straight in the room. And that is what's central to this appeal, is that she doesn't listen to the bradycardia for 3 minutes and then go into the room. She goes straight into the room. And that's what this consultant did and would have done with a bradycardia already having started, assuming that those are the facts I have to rely on for the purposes of this appeal. Of course, in the real world with the CTG running, there would have been, watching the CTG, everyone being more aware of what was going on, where everyone was, and various other things would have been different. I'm not seeking to make those submissions because I have to deal with the findings the judge has made. But on the findings that the judge has made, the bradycardia starts at 48-49. So it's already started when she's outside the room. And we know from the judge's questions to Miss Nix that she can hear the bradycardia through the door. And that's why she's able to say, when I heard it, I stopped writing my notes and I went in the room. She enters the room at 17:51, and that comes from paragraph 141, which is another summary by the judge of the timings. By 17:51, the transducer was sounding out the baby's heartbeat, which was bradycardic, and at the same time, Samantha Bond, the labour ward midwife, was outside the room talking to Miss Nix, who was on her ward round with Dr. Heath. Miss Nix wrote the start of her note at 17:50, then heard the bradycardia at 17:51, and went into the room at 17:52. So we have there the sequence that the judge found in terms of the timings. But what the judge has not dealt with there is that had the CTG been on, that bradycardia wouldn't have started at 17:51 when the transducer was attached, because it had started before the point at which the transducer's attached. It's already been, by the 17:51, on the judge's own findings, there's already been 2 to 3 minutes of bradycardia. And that is missed because the CTG is not running, and the CTG is not running because the defendants were negligent in the management of the labour, well, the pre-labour of this mother.
Could we look at the note that you attached, just so you can explain it
Of course,
to us? It's at
it's
in our core bundle at page 28.
I attached it for convenience to my submissions for this.
No,
Cool.
we can look at it in the core bundle at page 28.
Indeed, that's where it's attached to my skeleton.
So
There were questions about this, and I can take your lordship to the transcript on the
I
point.
don't want to go into any more detail than is necessary to understand this. It was just, I was trying to decipher this because it appears that Miss Nix's note begins with the timing on the left at 17:50
Yes,
and her name, ward round,
yes,
underlined in the second line. And then there's the beginning of a description of the patient.
yes, her agent.
And age and
powers.
and so forth. At that point, there might be 2 or 3 more lines below, which have been filled in, and then the note stops. Is that right?
My lord, yes.
Because
exactly.
of what you told us a moment ago, namely that she'd started writing a note, but had then been interrupted.
Indeed.
The only other thing I want to ask you about was why it was that there's a note apparently timed at 17:53 in the first line.
Yes, that was a question that my learned friend asked Miss Nix in evidence, and it's in the transcript, and she couldn't explain it. The only thing one can think is that the midwife picked up the note and wrote on it at the top of the page where there was a gap. It's a bit curious. We don't know.
It's unexplained, but
And it's
anyhow,
response, isn't it?
it is not.
Yeah.
But it was all gone into, and there it is.
And there was no explanation for it, but notes sometimes tend to get written where there's a gap without thought to the chronology. But what we do know, which is confirmed by Miss Nix, is she was outside the room writing her note and put the timing she started writing her note as 17:50. And the important thing for us is that if the bradycardia had been sounding as she got to the door at had been sounding from 17:48-9, when she got to the door at 17:50, she wouldn't have been standing outside writing her note. She would have gone in as she did at 17:51 when it sounded. And we say the case is very simple in the sense of 17:51.
17:52 is when she entered the room.
Is when she entered. 17:51 is when the judge said she heard it. That's paragraph 141. she heard it at 51 and was in the room by 52 is the way he described it. I mean, it may be, and Miss Nix's evidence was she couldn't be absolutely clear on the exact timings, but what she could say was when she heard it, she went straight in the room. And what is important from our purposes is she didn't say, I stood outside and listened for 3 minutes, because until you've had a bradycardia for 3 minutes, you don't know it's a bradycardia. And that's where we come to the difference between the Bolam position and the Belitho position. We know that this consultant, on hearing the bradycardia, went in the room. The judge's finding, when I come to it in a moment, is that after the bradycardia started, the midwife would wait 3 minutes before doing anything, then call the obstetrician, and then it would have been the same timing. And the flaw in that is it's not taking into account that there was a consultant outside the room by 1750, which is earlier than she heard it at 1751. So there is certainly that minute that can be saved, because she would have heard it at 1750, not at 1751, if it had been going from 1748 to 49. As soon as she gets to the room, she's going to be hearing this bradycardic heartbeat on the CTG that has been running. That's assuming no one's done anything about the CTG earlier and various other things. But what we do know is really that 1751 is not the same as 1750. And at 1750, we do know where the consultant is. My learned friend's respondent's notice, I think, refers to the fact that we're saying she would have been attending at 48 to 49, but that's not actually what we say in the grounds of appeal. We say she would have been, the difference was that the judge didn't take into account she is already there at 1750. She doesn't have to wait to 1751 when the transducer is attached, because it's already sounding the bradycardia from 48 to 49. I mean, it's a very short point, and it seems like it depends on a very short period of time, but that's what these cases depend on. So 1751 is when the judge says she heard it, and that's his finding. And again, I'm working with his findings. His paragraph 141, transducer attached, consultant hears the heart rate is bradycardic. That is 3 minutes later than his finding, 2 to 3 minutes later than his finding. It could have been heard if the CTG had been attached. 1752, having heard what appeared to be a bradycardia, she enters the room, and that is also apparent from her witness statement, which is in the supplementary bundle at page 61. Is what she describes. Sorry, paragraph 4, page.
It is page 61, Ms. Gamble.
Oh, sorry, I'm looking in the wrong one. Page 61, paragraph.
It is paragraph
4 is where she describes that she was outside and heard what appeared to be a bradycardia, so she entered the room. And the paper trace had still not started by that point, and she does the ultrasound and acts, everybody agrees, remarkably quickly. But the experts also agreed that the time for delivery would have been the same with the bradycardia being heard earlier. It isn't that she's missed minutes, that's why it only took 13 minutes. The decision time would have been 13 minutes from when she made the decision, which in the event was 1755, and then the baby's delivered at 1808, but not capable of resuscitation until 1812. So that is the best we can do by way of a sequence from the judge's own findings, which I hope I've picked up the references. They're not always chronological, but there are references, I hope, that support that sequence of events. And what we say, and I'm coming now to the flaw in the judge's findings, is that the judge is massaging the minutes from the bradycardia starting by saying what a competent midwife could have done. And it's C171, paragraphs 296 to 8, that are crucial to this. So what the judge finds at paragraph 296, I find as a fact that when the CTG became bradycardic at 1748 to 49, the midwife would most probably have called for obstetric assistance within 1 to 2 minutes or a maximum of 3 minutes. So by 1749 at the earliest and by 1752 at the latest. Now that 3 minutes, whilst he doesn't say is the Bolam test, I will take your lordship and my lady to where that 3 minutes was put in cross-examination to the midwives as being the Bolam responsible period in which to listen to a bradycardia before calling for obstetric help. So our submission is that that can only have been, there's no other evidence that you would, of the 3 minutes, other than that would be the Bolam acceptable period of time. I find as a fact that Miss Nix was standing outside M's door on the labour ward at 1750. So on the but-for scenario, she would probably have walked into the room at the same time as she did in any event. I do not know where she was in the 2 minutes before 1750. Well, the problem with that is we're not only concerned with the 2 minutes before 1750, we're concerned with the time between 1750 and 1751, when we do know where she is. She's standing outside the door, and the transducer, because it's not attached till 1751, already 3 minutes into the bradycardia, she can't get to it until 1752, but she doesn't wait 3 minutes, as is suggested by paragraph 296, before anything happens in relation to the bradycardia. So the simple point is that we say that what the judge has done in terms of his analysis of what would have happened is to apply the Bolam test, which is what would have been responsible, rather than say what would actually have happened on what we know. And no one disputes that the consultant was in fact outside the room at 1750 before the bradycardia was heard in the events that happened, but after the time the bradycardia would have started on the findings of fact of the judge, that it started at 48 to 49. So it cannot be brushed over on the basis of there could have been a 3 minutes gap, because we know that this consultant was the consultant who was standing outside the room, and we know what her action was. As soon as she heard the bradycardia, she walks in. She doesn't wait the 1 to 2 minutes or a maximum of 3 minutes So the judge is stretching the time to 1752, which is the time that the consultant actually walked in, by saying, and the only sense we can make of that is to say, he's saying it wouldn't have been negligent for a midwife to have waited 3 minutes before calling the consultant. And that ignores a consultant standing outside who is going to walk in the room. So it is a straightforward, we say it should have been a straightforward application of the Belitho criteria, which, and Belitho is in the...
Well, just before we go away from these two paragraphs, what is the finding that you say the judge ought to have made? Is it that Miss Nix should have walked into the room at 1750?
That standing outside the room at 1750, she would have walked in at the latest by 1751 if the bradycardia was already not 1752.
I mean, I'm just trying to anchor your critique to this particular passage in the judgment. So your complaint is to paragraph 297, where the judge says she would probably have walked into the room at the same time as she did. Your proposal is that the judge should have said she would probably have walked into the room a minute earlier.
Indeed, my lord, yes.
Is that the
on these
is that
findings,
the product of your
yes.
submission?
Yes.
Thank you.
That what the flaw is to say that the midwife would most probably have called for obstetric assistance within 1 to 2 minutes or a maximum of 3 minutes.
I understand that. I'm just trying to see where this lands,
Yes.
and where it lands is that you say that the judge was wrong to say that Miss Nix should have walked into the room at the time that she did, and he should have instead said that she should have walked into the room a minute earlier.
That she would have done on the evidence that he'd heard, which was as soon as she heard the bradycardia, she walked in. Whereas
Yes.
it can't be if she's outside the room at 1750 and she doesn't hear the bradycardia till 1751, that can't be the same scenario on a Belitho basis of what would the doctor have done as the bradycardia already sounding by the time she gets to the room at 1750. That must be a different situation. And the judges elided the situation of a midwife being able to take 3 minutes before she calls the obstetrician with the situation of a consultant who has said, as soon as I heard the bradycardia, I went in the room. And as soon as she heard it, in the but-for scenario of a CTG running, would have been at the very latest when she arrives outside the room at 1750, not when, as he's clearly found, it isn't audible until 1751. It's audible 3 minutes earlier on his findings. And she is outside the room at least a minute before she hears it, and she would have heard it on arrival on his findings as to when it started if the CTG had been running.
Ms.
Cannot
Gamble,
be said
can
that that's the same.
My apologies for interrupting you, but can I just get this clear? Are you now accepting that the start time for Miss Nix outside that room is 1750?
That's the finding of the judge, which we have to find, yeah, which we have to accept.
You're now accepting that?
I think we always have. I think the criticism that...
No, I don't think that's correct, Ms. Gamble. That isn't what your grounds of appeal were going to, and indeed, when Lord Justice Stewart Smith gave permission to appeal, he directed his permission to the fact that you were seeking to overturn a finding of fact at around 1750 and putting Miss Nix's presence outside the room 1 or 2 minutes earlier. So please can we be clear what now you are saying?
The primary submission, and when we come to the grounds of appeal, it always was the primary submission, was that being outside the room at 1750 still made a difference to when she would have walked into the room if you applied the Belitho test rather than the Bolam test to the start of the bradycardia. There was a further point that she had, that midwife Reeves's witness statement had said that she had come into the room and called midwife Bond out, and therefore we knew she was around just before, but that was as far as we could take that.
Forgive me, Ms. Gumble. I'm sure the fault is mine, but I just want to be absolutely clear. What is your position today?
The position today is that the first and main ground of appeal is that on the judge's finding of the consultant standing outside the room at 17:50 writing her notes, and the bradycardia not being heard till 17:51, that the point at which she would have entered the room was at least 1 minute sooner than she actually did, because she didn't hear the bradycardia till 17:51, and she would have heard it at the latest by 17:50.
Right, so when you say at least 1 minute, do you mean not less than 1 minute and not more than 2 minutes?
Well, I think it makes no difference, because we say the judge has found that every minute counts, so 1 minute is 1 minute.
I'm just asking you what do you mean by at least 1 minute, because that's potentially a
1
very
minute.
wide range.
On the judge's findings, using the same timing for her entering the room, because his findings are, which are his findings rather than exactly what Miss Nick said, but his findings were she was outside the room at 17:50, she heard the bradycardia at 17:51, she entered the room at 17:52. Those are his findings that I've taken the court to, and I'm not seeking to upset his findings. I have to work with those findings. So it is 1 minute, because 17:50
Yes,
is
well,
1
that's
minute
what
earlier
I
than
thought your
17:51.
submission amounted to, and that was why I was trying to see what an amended and acceptable paragraph 297 from your point of view would have consisted of. So it wouldn't have been at the same time as she did, but it would have been a minute earlier
A
than she
minute
did.
earlier, my lord.
Well,
Yes.
we've got that, thank you.
So, are we to take it that being your primary ground, are you now pursuing what was clearly contained within your grounds of appeal and addressed by Lord Justice Stuart Smith? Are you seeking to contend she was outside that room any earlier than 17:50?
I am saying that the judge made no findings in relation to to the taking, because I raised that in closing submissions, but there simply are no findings in relation to that. So if I'm relying on the judge's findings, which is what I accept I need to do before this court, I really have to rely on the findings that he has made rather than the findings he could have made in relation to her calling the midwife out of the room. But I will go to the grounds of appeal, because I think it's important that I specified there that it was from the standing outside the room in the first ground of appeal.
Well, in your grounds of appeal, you're attacking the final sentence of 297, where the judge said, I do not know where she was in the 2 minutes before 17:50, and you were seeking to construct it that by reason of one sentence in midwife Reeves' statement.
Yes, that was an alternative ground, but I can see that because the judge has made no findings on that, it's difficult for me to pursue that. And I don't need to if every minute counts from 17:50. I have a minute in which there would have been a real difference.
So are you pursuing it or not?
My lady, no, I don't think in the circumstances I can pursue where she was, because the judge simply hasn't
so
dealt with that.
That's ground 3 we needn't concern ourselves with.
My lord, yes.
Thank you.
The main ground, and the ground that I am pursuing, is that he did know she was there at 17:50, because that is his own finding,
Yes.
and he has ignored the fact that that is earlier than when she heard, on his own finding, when she heard the bradycardia.
So you've been helpfully addressing point 6, which is flaw in the findings. And so I just want to make sure, because it's very important that we fully understand what we have to consider. the flaw which you refer to in your point 6, which we've been looking at just now,
My lord, yes.
is the flaw to judgment 297.
My lord, yes. To
And,
saying
and
it would have been.
relates to the fact that instead of 1752 in effect, it should have been 1751.
My lord, yes.
Good. Well, that's clear. And I don't want to stop you from going on from there, but at the moment that's what we've understood to be meant by point 6.
And it's the fact that we do know where the consultant was at a time before the bradycardia could be heard because of the late application of the CTG. We do know that she could have been in the room earlier because she was outside at 1750. She couldn't hear a bradycardia at 1750. She had to wait on the judge's findings to 1751 and then went in the room. I mean, it's a very short point, but it is an application, we would say, of the Blytho test, which the judge didn't apply, even though we addressed him on Blytho at some length. But at tab 2, page 22 in the authorities bundle, this is, we say, is on all fours with this situation. That's page 22. And there is then there's the second paragraph down, reference to Bonington's casting and Wardlow and Wilshire. And the question, 3 lines down from that, the question is what would have happened if an event which by definition did not occur had occurred. In a case of non-attendance by a doctor, there may be cases in which there is a doubt as to which doctor would have attended if the duty had been fulfilled. But in this case, with no doubt, if the duty had been carried out, it would have been either Dr. Horn or Dr. Roger, the only 2 doctors, St. Bartholomew's, who had responsibility for Patrick and were on duty. Therefore, the present case, the first relevant question is, what would Dr. Horn or Dr. Roger have done if they had attended? As to Dr. Horn, the judge alleged the evidence that she would not have intubated. By inference, although not expressly, the judge must have accepted that Dr. Roger also would not have intubated. Therefore, the Bolam test has no part to play in determining the first question, what would have happened? And then there is further down the page the reference to the a case of Joyce and Merton and Sutton, which is where this explanation of the 2 ways in which the claimant can succeed, either by showing what would have happened or by showing what would have happened would have been a breach of duty. But the first way, the plaintiff can discharge the burden of proof on causation by satisfying the court either that the relevant person would in fact have taken the requisite action, although she would not have been at fault if she had not, or that the proper discharge of the relevant person's duty towards the claimant required that they take that action. And that's exactly what we're applying here. We're not saying that if she hadn't entered the room, in 1 minute it would have been negligent. We're saying we know what she would have done, and she was asked if the bradycardia had been heard earlier, what would have happened? Delivery would have been earlier, and I can take the court to that part of the evidence in the transcript. So we're in the first limb of we know which doctor it was, we know where they were on the judge's findings, and we know what she would have done because she's told us what she would have done, and we know what she did 1 minute later. So it's a very simple point that we're saying the 3 minutes must come from the second limb, the Bolam criteria of it would have been responsible for it wouldn't have been a breach of duty if the midwife had waited 3 minutes before calling the obstetrician.
But I mean, the net product of all of this is to shift the timing by a minute.
My
And
lord,
I
yes.
don't disparage that, because I quite
Yeah.
understand that a minute can be very important. But that's the product of it. And when we're thinking about the legal theory in the authorities, that's what the product of that conceptualizing is.
My lord, exactly.
Yeah.
It's that what those paragraphs of the judgment ignored is what the consultant he'd heard from would have done. It's looking, and although my own friend says, well, he doesn't say it's the Bolam test, there is no other explanation for the 1, 2 or 3 minutes other than that is what the midwives expert evidence and the consultants had said would be responsible, and that you could wait 3 minutes in order to attend to make sure that you knew it was a bradycardia. But what we know here is that consultant didn't think that was the thing to do when you heard a bradycardia. The thing to do, if you're the consultant on duty, is to get straight to it and see what's going on. And that is ignored in that analysis. So what we know is that, and we see that in the transcript, which is in the S bundle at 189, 190. Sorry, that's 193 to 4 of the supplementary bundle. I'm sorry. Sorry,
It's the transcript of
supplementary
your
bundle.
questioning of Miss Nix, is it?
I'm sorry.
Your questioning of Miss Nix, is it?
Yes.
Right.
And
What page are we looking at?
it starts at 188 in the supplementary bundle behind tab 12.
Yes. Is there a passage you want us to read?
The first bit is just the explanation as to you would hear from the transducer the heartbeat, and the judge asked the consultant how that happens, and she explains that you can hear it through the door. And then the questioning starting at line 16, you heard the bradycardia as a heartbeat of 50, but you had no way of telling whether this was the beginning of it or whether it had started earlier. Answer, yes. So if the CTG had been running, somebody would have seen it when it started, and that wasn't necessarily when you happened to hear it outside the room. Yes. And if it had been seen earlier than 1750 when you recognise it, then action would have been taken earlier. Yes. Now, at that point, of course, it was thought that the bradycardia would have been recognised much earlier because that was the evidence, but she accepted in terms of the decision, it was a bradycardia that the sooner you recognised it, the sooner you take action. So that, but the probably the more important point is we know what she did, and there's no basis that it can be said, well, she would have waited longer if she'd heard it at 1750 than 1751. And that simply isn't addressed the judge simply doesn't address the Bolito situation of what would this consultant have done if the bradycardia had started before she got to outside the room and she could hear it as soon as she arrived. It simply doesn't address that. So the 3 minutes we can only think came from the judge's taking the expert evidence that waiting 3 minutes would be reasonable if you were a midwife, and if you weren't sure of the consequences of the effect of hearing the low heart rate. And that's the agreed obstetric evidence, and it's in Core Bundle 157 at paragraph 190. Both obstetricians agreed that once bradycardia was appearing on the trace, it would take probably only 3 minutes for that to be properly identified as distinct from a deceleration. So that's one place that the 3 minutes may have come from. The other is the cross-examination of the claimant's expert, which the judge refers to at C 160, paragraph 208. Defence counsel wholly properly put to Miss Leonce, sorry, that's the obstetric expert in cross-examination, if M had been connected to a CTG on the labour ward on the but-for scenario, the following timings would have been reasonable. So that, we say, is a question about the Bolam test. Bradycardia would have started 1746, would have taken 3 minutes for the midwife to recognise the bradycardia and call the obstetrician at 1749. So the reasonable test, which it appears is what the judge must be referring to in referring to the midwife waiting 3 minutes, is the 3 minutes, because he doesn't explain in the judgment why he's saying 3 minutes in any other way, but we can see from the expert evidence that he heard that he could find that 3 minutes on a Bolam basis would have been a reasonable interval of time. So I hope that makes clear how we put that. And
Well, the essence is it that if, as should have occurred, the CTG would have been running, Miss Nix is outside at 1750. Whatever the midwife would or would not have recognised, Miss Nix at 1750 would have heard the bradycardia, and on the timings would have been in by 1751. Is that it in essence?
my lady, yes, it is a very short point, and I hope I haven't laboured it too much, but it's because there's so many timings in the judgment, which is why I've tried to set out the chronology with the references, and because the judge really never takes that sequence in the way that we've sought to do on this appeal to see what the differences would be. And we say the flaw is simply in that paragraph where he says the midwife could have waited 3 minutes. He simply doesn't say, but I know the consultant was outside at 17:50 and I know she didn't wait 3 minutes. She simply went straight in. And then there's the every minute counts and you save time at the end as well.
The knock-on effect then on delivery time would similarly have been 1 minute.
Everything is 1 minute shorter, yes, because
So
the
that,
consultant...
it would take that amendment, paragraph 298, then consequent on the amendment to 297.
My lord, yes. And the consultants agreed that it would be 13 minutes from a decision to deliver as actually happened, would have happened, whatever the actual timings, so that there was no argument that there was, and the judge didn't find that there was more of an emergency 1 minute later. Paragraph C in Court Bundle 158, paragraph 193. This is the obstetricians both agreed that once the bradycardia had been identified, the time to C-section would have been only 13 minutes. A superfast C-section, which was in fact what happened on the day. So the judge is recording at 193 that once you identify the bradycardia, the time to delivery would be 13 minutes, which is actually from the 55 timing when she makes the decision. But if everything moves forward a minute, you still get the 13 minutes from there. And the judge didn't suggest that would be different with different.
So it would have been 1807 rather than 1808 delivery.
My lord, yes. And then the resuscitation.
Yes.
And if every minute counts, which is the judge's own finding, then it makes a difference with this kind of level of catastrophic injury.
So in other words, one is basing it on what in fact Miss Nix did as soon as she went into that room.
My lady, yes, exactly. Belitho, it's a very good example, we would say, of the Belitho principle. When you know who the consultant would have been, where they would have been, and what they would have done, you don't apply the Bolam principles. Of course, on a Bolam basis, you might be said you didn't have to do it in 13 minutes, but the obstetricians agreed that it would have been 13 minutes from whenever the bradycardia was recognised. And the fault with the defendants is they didn't have the CTG running, and it was 3 minutes into the bradycardia on the judge's findings that the consultant was able to identify it. And of course she acted amazingly promptly then, but there's no suggestion that you could then apply a Bolam test and say she might have done it slower. You just transpose on a Belitho basis what actually happened to what would have happened in a situation of non-negligence, which is a CTG running. And of course this is a very narrow point because I'm relying on the factual findings of the judge. And the next point I make is that whilst the defendants criticise the appeal as trying to upset findings of fact and refer to authorities that say you can't upset findings of fact unless they are plainly wrong, I'm not seeking to upset findings of fact. I'm going with the judge's findings of fact and saying that his fault was to fail to apply the Belitho principle to the findings of fact that he made. I'm taking all the timings and all the findings of fact from what the judge found.
So can you then put this together with the evidence which was largely agreed about what difference a minute would have made in this case in terms of the severity of the injury? How does it fit with?
Well, the finding of the judge was that every minute would,
yes, but
any saving would have made a difference.
But I mean, clearly, you've taken us earlier on to to the advice which was given, and I don't think it was very contentious between the doctors as to what the first 10 minutes amounts to, and what the next 10 minutes or next 5 minutes amounts to, and the next 5 minutes, and so forth. So could we just situate what you say a minute would have led to in the context of that advice?
Well, we say that, and it's probably best explained in the subsequent judgment by the judge, because he's dealing with it there, where he's finding for the claimant. But in this case, what the judge found was that any saving in time would have made a difference to the outcome. And no, in this case, the material contribution argument was accepted by the defendants, providing you got delivery by 1805, but not accepted after that. And the judge dealt with the illogicality of the defendant's evidence that, and I can take your lordship to that. I'm sorry, that's one of the passages that I skimmed over for not going through the detail, but if I can go back to it, it's in the core bundle 168, starting at 271. I'm sorry, yes, probably should start at C166.
Well, it begins paragraph 252, does it?
Yes, where that was the analysis of
Professor Mitchell, whose evidence
Professor
the judge
Mitchell.
preferred.
And then 254, he was of the firm view that any saving of time or duration would avoid primary some injury, except that it was not possible to apportion the functional outcome between damaging and non-damaging. And that was the issue in the later case, was whether you could have the allocates that Dr. Rosenblum was suggesting for being able to tell what the difference was.
Miss Gumble, can I just add a note of caution of the case you're relying on? There was a notice of appeal in that case.
My lady, I'm aware of that, and I think it's, but I think permission to appeal has been refused and the appeal's been abandoned.
Well, I refused the permission to appeal.
My lady, I wasn't aware of that. But it isn't going to be subject to, it can't be said it's going to be subject to an appeal.
No, but all I want to say is this: please be cautious on how you deal with that later authority, and any reliance on it.
My lady, yes, I'm really only relying on it if it was said that the judge didn't mean that any amount of time, because clearly that's how he interpreted any amount of time as 1 minute. Whereas in this judgment, he's saying it was firm of the view that any saving of time, so arguably even less than a minute, or duration of PHI would avoid primary some injury. He accepts it was not possible to apportion the functional outcome between damaging and non-damaging PHI on the facts of this case. However, he did not accept the general question asked by defence counsel in cross-examination that once the claimant had entered the damaging period, it was impossible to say whether earlier delivery would have resulted in a better outcome. It was Professor Mitchell's firm opinion that the shorter the duration of PHI, the lower the level of primary injury that would have been suffered by the baby. And that matched what Dr. Pike had said in quite short terms, and the judge said it was a pity he hadn't had more evidence from Dr. Pike on the point. But and then there's the point I've already made at 257, that it, and the reference to Dr. Pike, but when analysing the evidence, and then there is reference to the Dr. Pike's evidence, which I've already referred to in his report, but that's set out in paragraphs 259 and 260. Then Dr. Connolly's evidence, the neuroradiologist, at 262, had the delivery been achieved before 1753, all the brain damage would have been avoided. Had delivery occurred before 1808, some brain injury would have been avoided. So that was the neuroradiologist. And then there is analysis of the defendant who didn't accept the some injury in the last few minutes, which is Dr. Jane Horden on page 168. She advised on the balance of paragraph 271, taking into account the severity of the injury, her estimate of the duration of the PHI would be around 20 minutes, likely to have persisted for 2 minutes after birth and the return of circulation. Dr. Horden had counted from 1810, which was birth plus 2 minutes, and asserted the PHI started at 1750, allowing for 10 minutes of compensation for the fetus, during which the fetus would not have been damaged. She calculated the damage started from about 1800. She accepted delivery after 1800, but before 1808 would have resulted in less severe injury, said it may or may not be quantifiable depending on the length of the negligent delay. And then, in cross-examination, she told the court that you couldn't calculate the length of the PHI from those factors, but in 277, Dr. Horden was unable to say whether under 5 minutes of reduced PHI would have made a material difference. She considered that 5 minutes or more would have made a material difference. When challenged by the claimant's counsel over the logic of that evidence, she refused to alter her position. The challenge was made on the basis that Dr. Horden asserted if the claimant had been born by 1803, a better outcome would have resulted. On her own evidence, the damaging period of PHI started as 1800. Therefore, only 3 minutes of damage would have occurred by that stage. However, she was not prepared to accept that if birth had occurred 3 minutes earlier, by 1805, that would have made a material difference. So that was her cross-examination, that if she was saying it wouldn't have made any difference. And the judge then preferred the evidence of Professor Mitchell to that of Dr. Horden. Paragraph 280, I found Professor Mitchell's explanation of the likely duration of PH more persuasive than Dr. Horden's. However, there was much of Miss Horden's evidence which I accept as well. Consider she was a little too rigid over the material contribution issue. Seems to me, and I so find, that any reduction in the period of PHI would have reduced the primary injury to the claimant's brain neurons. So that was as far as he found. And didn't agree with Dr. Horden's evidence that you needed 5 minutes, but did agree with Professor Mitchell, Dr. Connolly and Dr. Pike that any saving made a difference. So, does that assist, my lord? Was that the point your lordship was?
That's helpful, thank you.
So, in terms of the
you're going to come to the pleadings, but I was just situating the evidence that those doctors were giving in the context of the issues that had been presented to the court at that stage. It may be convenient for you to do it in your own way, but I think we see the amended case that you had pleaded around paragraph 26 of the judgment, 26 to 28.
My lord, yes, both parties, of course, made.
We can go to the actual pleadings in a moment, as I'm sure we will, but it looks as if your case, which was being considered in the evidence, was delivery by no later than 1803.
That was
a saving of 7 minutes.
But we didn't confine it to that. That was when the experts at the experts meeting had agreed the and it turned out wrongly agreed 1743 for the start of the bradycardia when they meant 1746, and so the 46 to 53 was the 7 minutes. So that was based on the expert evidence at the time.
All right, well,
Because we see from
we'll
paragraph
follow you through. Are you going to take us to the pleadings now?
My lord, yes, I was just going to make the point briefly that there is that the respondents make the point that we are seeking to upset findings of fact that the judge has made, and what we would say is we're working within the findings of fact that the judge has made. We're not seeking to upset his findings. His findings of fact are the timings at which the bradycardia, the timing at which the bradycardia would have occurred with the CTG attached, the time that the consultant was outside the room, the time that she went in, and what happened. And what we are attacking is the judge's analysis on the but-for timings that the midwife would have waited 3 minutes, which is not a finding of fact, but an application of the Bolam test. That's the difference between us on that.
Yes, we've followed, we've understood that. Are we now going to see how it was pleaded?
My lord, yes. The pleadings, the history of the amendment is set out in paragraph 25 and 26 in the judgment. Of course, at the start of the trial, both parties were seeking to amend the pleadings. Our amendments were based on what had happened at the experts' meetings. The defendants were based on the fact that their doctor was now saying he hadn't made the note, that it looked as though he hadn't done an examination. So there was quite a radical change in the pleadings, the defendants' pleadings as well, on something that we could not have anticipated or understood in terms of whether he'd done 1 or 2 examinations. But in terms of the pleadings, at page 993 in the core bundle, the amendment that we made, sorry, it starts at the bottom of page 92.
The sequence was that the defence was amended first, and yours was amended very shortly afterwards.
I think we had a draft amendment. I think both amendments were formally made before the judge because both parties needed permission. But in fact, the amendments made by the defendant are not relevant to these issues. They're relevant to the history for getting to the labour ward, which obviously was important.
So you gave a page reference a moment ago, which was 90.
Bottom of page 92.
Thank you.
Alternatively, if the claimant had been delivered at a later point, between 1753 and 1808. So
Do you mind if we go back?
I'm
Just
sorry.
take the sequence. Does it start at 5.4?
um,
The sequence of assertions.
the original on this pleading, yes, 5.4, we are working on the timings of the bradycardia that the experts had taken in the experts meeting. So we were saying any event before 1803 is paragraph 5.4. On the balance of probabilities, the claimant would have avoided all of the damaging hypoxic ischemic insult, or would have avoided a further 3 minutes, that being on the basis of the timings that we were then working on. The additional 15 minutes from 1753 to delivery at 1808, and a further 3 minutes after delivery, because the experts were working on 1811 rather than 1812 for resuscitation. So that's where the 3 minutes after delivery, it only turned into 4 minutes in the judgment, with the judge rounding up the 3 minutes and 30 seconds on Professor Mitchell's evidence. Claimant had been delivered by 1753, she would not have suffered any or any permanent damage. Then the further pleading at 5.6, alternatively, if the claimant had been delivered at a later point between 1753 and 1808, so that is any time earlier than 1808, the claimant would have suffered either no damage or less severe damage. That is, the delay between 1753 and 1808 made a material contribution to the claimant's severe injury.
Well, it seems that looking at this in a broad way, that 5.4 puts up a case of 3 minutes.
Yes.
5.5 puts up a case of no permanent damage at all, and 5.6 appears to have settled in delivery around 7 minutes earlier.
But makes the
I appreciate what you've just read to us, but then there's a passage of amendment which focuses on a 7 minute shift in the clock.
My lord, yes, but the original pleading, and so it's not even the amended pleading, is that any earlier delivery before 1808 makes a material difference. Because that's the first sentence. The first sentence.
I follow that, but that wasn't the actual case presented by 5.6. It wasn't. It was a 7 minute case was being put by that.
That was based on the experts meeting, the amendment, but without the amendment, 5.6, the alternative case originally pleaded, and I can take my lord to the further and better particulars request on that, was that any delivery between 1753 and 1808 would have suffered either no damage or less severe damage. So the pleading was that any delivery before 1808 as the yet further alternative. And we then, maybe it should have been a separate paragraph, but we made a new case from the experts meeting in the underlined part in relation to the 7 minutes, but it doesn't detract from the original pleading. And we see that from the response to the request under 5.6, and so the original 5.6 was any delivery between 1753 and 1808, and the defendants asked for further information about 5.6 in its original form, and we see that at 103H. Under paragraph 5.6, alternative, the claimant being delivered later point between 1753 and 1808 would have suffered either no damage or less severe damage. That is, the delay between 53 and 1808 made a material contribution. The question was, when on the claimant's case is the latest point in which earlier delivery would have made a material difference to the nature and or extent of the claimant's injury. So they knew when they asked that question that we were making the case of any earlier delivery.
Would you just give the
I'm sorry,
page
it's
reference
page
to that again?
103H.
Thank you.
And the response at 103H was,
I'm not in the right place, I'm sorry.
I'm sorry, it's the core button, it's been given an H number because it wasn't in the original bundle. I hope it's been added to.
I'm looking at the core bundle. Nicola?
Yeah.
Where is this?
There, 103.
I see, okay. Sorry.
I'm so sorry, can I hand in a...
No, it's the numbering that I have in the electronic version.
So you are now working on the premise that delivery should have been found to have been by 1807.
My lady, yes.
So resuscitation would have been
1011.
1011.
What we make here, before any amendment to the pleading, the defendants were aware, in answer to their question, that we were saying that every minute made a difference, and that we were alleging, as a last allegation, of course we were making allegations based on our expert evidence as to when the CCG should have been started and when the bradycardia started, which were different. But our last allegation was, and it may be a sweeping up allegation, that any earlier delivery, that the breach was not delivering earlier than 1808, and when asked which the latest point at which delivery would have made a material difference, we are saying that delivery and resuscitation achieved before 1800 were on the balance of probabilities avoided all damage. Every minute of delay between 1800 and 1811, when the claimant's heart rate rose to over 100, caused or contributed to the overall catastrophic damage suffered by the claimant. That's where we make the point that Professor Mitchell made, so the defendants were aware that we were making, it might be quite a broad point to say, but of course we don't then know what findings the judge is going to make as to the precise timings, but we have laid the ground for any earlier delivery would have made a material difference for every minute that counted. And we've made the allegation in paragraph 5.6 that delivery should have been before 1808. It's difficult to see how we can plead the case on every minute when the findings, and we have the difficulty, of course, that everything that we're trying to allege is on the basis of a CTG not being put on when it should have been, and on statements that turn out to have given timings that were not right either. We have quite considerable difficulty in pleading a case with treating doctors who are recording examinations they haven't done and who haven't transferred to the labour ward when they should have done, and as to what they would have done thereafter. So we're having to plead it in a broad way, in a sense, because we don't know what the judge is going to be able to find on the evidence that appears at trial, which is, you know, why you needed a trial. And we are then working with the judge's findings. But I think it's difficult to say we didn't plead, and you know, we couldn't have done at that stage, that the consultant standing outside the room would have gone in a minute earlier, because we didn't know the judge was going to make the findings that he did. Our experts and the defendant's experts had given a different timing for the bradycardia starting. But once we've got the judge's findings, we said the judge had to follow through those findings, and it certainly wasn't the reasoning of the judge that we hadn't pleaded that case. It was the reasoning of the judge that you could responsibly wait 3 minutes before you called an obstetrician. So I think it's unfair to say we didn't alert the defendants to the fact that we were saying any earlier delivery was a breach and would have made a difference, because as clearly as we could at that stage, we suggest we did at least set that out.
In broad terms.
I'm so sorry, ma'am.
In broad terms.
In broad terms, indeed in broad terms. And it's very difficult to do other than that when the defendants haven't done the things they should have done, so you don't know at what time different events would have occurred. So I come then to the grounds of appeal, which are at Call Bundle page 72. And the learned judge erred in applying the wrong test to the findings that the claimant's fall in heart rate would have commenced at 17:48:49. The learned judge asked what time would have elapsed with a midwife exercising competent care within the parameters of the Bolam test, and found she could have waited 3 minutes before calling an obstetrician. The learned judge should instead have asked what the consultant, Miss Nix, would have done applying the Bolitho test. Applying the Bolam test, the judge found Miss Nix would not have entered the claimant's mother, I think it should be the claimant's mother's room, any earlier than 17:52, the time when she actually attended. Applying the Bolitho test, the learned judge should have found she would have attended at least 1 minute earlier, that is by 17:51 at the latest, and that is the submission I've been making.
Well, it is, but I think the submission as we've received it, and I'm not seeking to box you in, but I'm
Yes.
seeking to establish as much clarity as we can, so that she would in fact have attended 1 minute earlier, that is by 17:51.
Yes, I think that, well, that, isn't that what that's what
No,
the
you say
grounds.
at least a minute earlier,
Right.
and that's by 17:51 at the
Right.
latest. And so I think that on
Right.
the basis of our previous conversations, we can delete at least and at the latest in that submission. Yeah, thank you.
That's my fault. Miss Nick's evidence was that as soon as she heard the heart rate fall, she entered the labour room, and that would have been the case if she'd heard the heart rate fall earlier.
Yes. Well, that's not so much a ground of appeal, that's commentary.
Yeah.
The ground of appeal is in the previous sentence.
The learned judge failed to apply his own findings of fact to the timings so as to determine that with the bradycardia beginning at 48:49, the claimant could and would, with the same consultant in place, have been delivered. And again, it shouldn't be at least, it should be just 1 minute.
1 minute, yes. Well, that's helpful.
So I hope that is the main, that I haven't deviated too far from the grounds of appeal. I appreciate I did say at least, and I perhaps was being over ambitious there. But in fact, we would say it doesn't matter whether it's 1 minute or at least 1 minute. And perhaps it's entirely my fault, perhaps I shouldn't have said it at least. But I am making the point that it is the 1750, 1751 in the grounds of appeal as I understood them. And where the consultant was, I think, must only come from the fact that I do in the skeleton argument say, and actually, you know, on the ground there may have been even earlier, because we did have this evidence, and that was argued before the judge, that the midwife had been called out of the room by the consultant. But I don't think I can take that any further by way of this appeal. What I'm seeking to do is work from the secure findings of fact of the judge and quarrel with his application to those facts of the timings in order to save, I appreciate, only 1 minute, but 1 minute is 1 minute in terms of hypothesis.
We had a conversation which I had prompted about ground 3, and I'm now looking at it again in the context of what you've been telling us. That
I'm sorry.
I think had in my mind that ground 3 depended upon you disturbing the judge's finding about Miss Nix's whereabouts. That's not correct, and it may have been a misunderstanding on my part. So ground 3 survives and can be read in the same way. The judge failed to consider, as he ought to have done, the consequences of saving of 1 minute and whether this made a material difference. That's ground 3, is it now?
Other than to find that every minute counted was as far as he went in that respect.
Yes.
Unless I can assist with anything.
So, I mean, it really comes to this. I'm going to look at paragraph 297 of the judgment. The finding of fact is that Miss Nix was standing outside the room at 17:50. And the finding of fact was that she'd probably have gone into the room at the same time as she did in any event. And you say that's simply wrong, because if the CTG had been attached properly and the transducer working and so forth, at 17:50 she'd have heard what she in fact heard a minute later. So that finding of fact was wrong, and he should have said she'd have gone in at 17:51 rather than 17:52.
My lord, yes, but it's because it followed. We would say that can't be looked at in isolation without the paragraph before. The finding that she would have gone in at the same time is dependent on the 3-minute wait from the midwife, because otherwise
I'm not sure this. I think all you need is the point that
yeah.
I mean, if it's the case, and obviously we have to think about this, that that was a case that was squarely before the court, and that every minute counts, then all you need is the minute.
Indeed,
Yes,
that's
all this business, if you'll forgive my saying so, about both in but life though, and what he says in 296 really doesn't matter. If at 17:50 Ms. Nix was outside the room, and at 17:50 there ought to have been a trace operating and sounding bradycardia, that would have caused to go in a minute earlier.
yes.
And everything would have been
All I was
accelerated by a
seeking
minute.
to do was to try and explain why the judge had thought it was the same timing, and the only explanation, the only sense I can make of those two paragraphs is the judge thought the timing would be the same because he allowed the midwife 3
Yes.
minutes. Otherwise, I can't make any sense of those
I
two
think
paragraphs.
our response to that might be, well, that's all well and good, but you don't need that.
Right. Well, if I don't need it, that's
in
fine.
a
But I
sense,
was trying to.
If your straight road to saving a minute is a firm foundation for your submission, then the theorising doesn't really.
And if I can then go back, let's assume a minute matters, to paragraph 280, and the last sentence, it seems to me, and I so find, that any reduction in the period of PHI would have reduced the primary injury to the claimant's brain neurons.
Yes.
And that's his finding of fact.
Yes.
What do you say is the consequence for us if we accept that there was a minute lost in terms of the outcome of the appeal.
Well, we say that the appeal should be allowed and that the claimant should succeed because every minute makes a difference, and he hasn't found that you can divide it up. The defendants have accepted material contribution for anything up to 1805, but not, I'm sorry, is it 8? And there was no suggestion of dividing up the damage, because if the judge's own finding is that every minute makes a difference to the damage, then there's no basis that the judge said that, but it wouldn't have caused. I can divide it up, and I wouldn't have found, which is my third ground, as he hasn't made a finding and should have made a finding as to whether, if there was saving, he could divide it up. But he was, I think, working on the basis that the defendants accepted that with an earlier delivery, you wouldn't be able to divide it up. There wasn't ever any suggestion in this case that you would work on 5-minute allocates.
Well, and he preferred the evidence of Professor Mitchell, who had abjured any suggestion that you can engage in some kind of arithmetic calculation.
And Dr. Pike had specifically said that, although the judge said it was a pity he didn't have more from Dr. Pike.
Yes. Well, there's obviously comes a point where a de minimis argument might be advanced if you were talking about, for example, a second, 5 seconds or something like this. But we don't seem to have, do we, in any of the evidence, the commentary of any of the experts about the scenario which we're now being asked to contemplate, which is, would 22 minutes make any difference rather than 23 or 24?
Well, except we have Professor Mitchell.
Yes, I know, but that's as it were, a generalised statement without context. And the case that I think you have to meet on this is that there wasn't any context to it because this particular scenario was not put. And so in relation to my Lord's question, it might be said that we have some difficulty in simply substituting a finding of liability in circumstances of this sort, and that what you're in practice proposing is that this would have to be looked at again.
That would be an alternative if the every minute counts being the finding of the judge, every minute causes damage, and the accepting the expert evidence that you can't divide it up. And obviously it was argued on the basis of material contribution, and you will have seen from the pleadings, material contribution is sort of every other paragraph. If the judge has found that he's preferred the evidence of Professor Mitchell and accepted that, and has found that every minute counts, but the only reason he found against the claimant was he couldn't find a minute that would have been saved, then we would say it would follow from his own findings that the claimant would succeed if they could show he was wrong in not showing there should have been earlier delivery. But obviously I wouldn't want to abandon the alternative that there would need to be a retrial on that issue if that were the finding of the court, that because he hasn't made specific findings, then the alternative would be to have a trial on that point alone and expert evidence on what difference that minute would have made.
Well, in fairness to you, Ms. Gumble, I mean, you said in answer to my lord, when you were defending your pleading, that you didn't know final timings, and so there was, I don't mean this in a pejorative way, a broad approach to timings.
Yes, I mean, that was the difficulty, that everybody was giving different timings, and in fact the experts had agreed a timing for the start of the bradycardia that they then agreed was wrong. So we were struggling with what the experts
Yes,
had
and
agreed.
also you're entitled to say that a person in your client's position should have a benign treatment from the
Indeed.
court in circumstances that existed in this case.
Which is
I mean, we followed those points, yes.
why I've taken your lordships and my lady to the findings of breach, because although they're not absolutely, well, they're directly relevant to the failure to run the CTG, but they are relevant to the background of, you know, what this case is about and the difficulties that the claimant had in making the case. And, you know, there were difficulties which aren't relevant to these submissions in having a doctor who said he'd done an examination that he hadn't done, and then a midwife in the course of the trial saying she made notes that she hadn't made. There were a lot of criticisms of the defendants' experts which are relevant to the claimant in how precisely they can make the case prior to the trial, because there's so much that is misleading. The notes are criticised by everybody as being very misleading, and the difficulties in trying to make the case precisely when the notes are defective, the witness statements are found to be entirely misleading, and there is absent the documentation that you would need to make the precise findings. We would say, you know, for a child in this situation, it's quite harsh to say, well, you didn't make the precise allegations in terms of the precise timings that you're now making before this court, having had findings of the judge that we've got to work within.
Right.
Unless there's anything else I can say.
No. Thank you very much indeed. Campbell, thank you. Yes, Mr. Sheldon.
My lords, my lady, as you will have seen, the defendant has had some difficulty at various stages in these proceedings in identifying precisely the case that we need to meet. So it may be helpful if, before I launch into my submissions, I articulate what I now understand to be the claimant's case, to which I need to, or at least the parts of it I need to address. We are agreed, I think, that the critical paragraph for present purposes is paragraph 297. And it is at paragraph 297 where my friend says that the judge erred. It is now accepted, as I understand it, that that error does not infect the second sentence of paragraph 297. It is restricted to the first sentence.
Yes, we're not now considering what seemed to be a hot topic, which
Yes.
was what happened to Miss Nix beforehand.
Well, I'll tailor my submissions accordingly, my lord, and focus on the first sentence and the proposition now put that the judge was not entitled to have reached the conclusion that Miss Nix would have walked in to the room at the same time as she in fact did. The only conclusion that the judge could have drawn from the evidence was that she would have walked in 1 minute earlier. Now, my lords, my lady, that being the case, can I make 3 short points before I launch into the analysis that's foreshadowing my skeleton argument? The first is that that case involves the judge's conclusions being impugned on a factual analysis that was never put to him. Leave aside, for these purposes, the plea.
Fault is mine, I'm writing it.
I'm so sorry, my lord.
Right. Judge's conclusions are impugned, yeah.
On a factual analysis that was never put to him. We've looked at the pleadings and I will return to them. But my lords, my lady will also have seen the opening notes and the closing submissions that were delivered orally, or at least the relevant aspects of the transcript. And at no stage during the course of this trial, indeed during the course of this litigation, was it suggested to the judge that the playing field on which these issues were to be determined was restricted to the period 1750 to 1751. And that this case boiled down to a minute of precisely who was where and in a position to do what during that period. So he would have had no idea, no inkling, that the findings of fact and timings that he set out at, for example, paragraph 141, which my learned friend relies, would be subjected to the analysis in which we're now engaged and being used to construct the case that is now being constructed, simply been unaware of. And that is important when it is being submitted that the judge fell into legal error in making those findings. Second preliminary point, my lords, my lady, relates to timings. What is now being suggested to the court that this case can be determined on a minute analysis of 1750 to 1751, that minute, was expressly disavowed before the judge at trial. And can I take you to the relevant part of the closing submissions where the issue of timings and their precision was addressed? And for these purposes, I think the only reference I need is page 223 of the supplementary bundle, which is an extract from my learned friend's closing submissions. Now, at line 12, Ms. Gumbel says that if the CTG had been running, someone would have seen it when it started. It wasn't necessary when you happened to hear it outside the door, yes. If it had been earlier than 1750, which was the timing we were working on, but actually on analysis of the timings, that may not be strictly accurate. And everybody is talking about approximate timings. What's going to be important is the sequence of timing rather than the actual clock timings. And then over the page, sorry, a few pages on, page 234, which is still in my learned friend's.
Sorry, do you want us to read the last sentence of Ms. Gumbel's
Certainly,
submission? I mean, it just seems to be on point. Not quite understanding what that means.
My lord, it's probably not for me to make submissions on what it means. The only point I seek to extract from this, and I'll come on to explain why in a little bit more detail in just a moment, is that throughout this trial, it was accepted that at least until the bradycardia is identified and you have in effect a scribe who is giving a minute-by-minute rundown of what is going on in the contemporaneous notes, all timings were approximate. And that is re-emphasised at page 234, again in my learned friend's closing submissions. Where my learned friend acknowledges at the top of the page, I know your lordship's understandably pressing me for specific times. It again comes back to the claimant's problem that because of the paucity of the notes and the lack of the CTG, giving minutes in precise clock times is an almost impossible exercise. And then same point about sequence of events.
But that, you're not comparing like with like here, are you? That Ms. Gumbel's submissions are being made in ignorance of what the judge is going to find.
Yes.
So don't her difficulties, as she would put it, in giving precise times arise from the fact that she doesn't know what finding is then going to be made?
In my submission, no, my lord, because what is now the case that is now being advanced is that there is a minute. It is asserted positively.
Yes.
A minute that Miss Nix is outside the room doing something other than intervening in the delivery of this baby. And that minute has been constructed from timings given by a judge without any understanding that this precise analysis of the timings is going to be necessary or important in circumstances where it was accepted by everybody in front of the judge that you cannot slice up these events with that level of precision. That's my point, my lord.
Sorry, when you, my,
Sorry.
sorry, when you say you can't slice up these events without any precision, are you talking about the events, the factual events, or what one might call the material contribution events?
The factual events, my
Right,
lady.
thank you.
The factual
My
events.
apologies.
You see, I'm so sorry, my lord. Did my lord have a question for me?
No, you carry on.
See, my lord, the starting point for this analysis is that the judge has made a finding, a factual causation, that having heard all of the evidence and listened to all of the submissions, he is satisfied that Miss Nix would have entered the room at the same time in any event. Now, what is now being done to impugn that finding and to persuade the court that he was wrong to make it is to construct a prior minute, which in my submission was never a factual proposition that was put to him. And in my submission
Terribly
couldn't
sorry,
have been, I'm so sorry.
No, my fault.
I keep
my fault
doing that.
entirely. Was it? I mean, the case is quite wide-ranging, but certainly a significant part of the claimant's case was the CTG apparatus should have been in place earlier,
Yes.
and therefore, had it been in place earlier, the brachycardia, which on the overall evidence would have become apparent 1748 or 49, whichever it was, then would have been audible. That was undoubtedly the case.
Yes.
And at 1750, on any view, Miss Nix was outside the door.
At around 1750.
Yes, well,
yes,
that's what she wrote on her note.
Yes, I'll come to her evidence in just a moment. Yes.
Yes.
Yes. And the judge found in the relevant passage at paragraph 297 that she acted on that at the same time she would have acted on it in any event. He found, in effect, that there was not a period of a minute, or whatever it might now be suggested it was, when she was standing outside the room in a position to hear the bradycardia, had it been running, had the CTG been running, in which she could have acted. He didn't make that finding. He found, on the contrary, for reasons that I'll come on to in a moment, on the contrary, that she intervened at the same time she would have done anyway. And my essential submission is that was a finding he was entitled to reach on the evidence. And this minute deconstruction of minutes, based on his judgment in circumstances where he was never invited to analyse it in this way, is not a proper basis for impugning his conclusions.
Forgive me, when you say he was never invited to analyse in this way, are you saying he wasn't invited to analyse from 1750 what in minute terms Miss Nix did?
Yes, my lady. I'm submitting that at no stage during the trial was the judge invited to make findings about where Miss Nix was and what she would have been able to hear in the 60 seconds prior to her actual intervention. That was never a task that was set for the judge by anybody. It wasn't an issue foreshadowed in the pleadings, in the opening, in the closing submissions, which I'll come to in a minute to identify the timings that he was asked to consider, or at any other stage. And because this is important, a point that I'll return to, if I may, my lady, in a bit more detail, but to answer my lady's question, because he was never asked by anybody to analyse where Miss Nix was and what she might have been in a position to hear between 1750 and 1751, none of the evidence that might have been called to elucidate that issue was heard. No one asked Miss Nix about it. Miss Bond, the midwife who was supposed to have been talking to Miss Nix during this 60-second period, was never called by anybody, never suggested she should be. Dr. Heath, the registrar, who was with her on the ward round, and presumably would have been able to speak to her whereabouts between 1750 and 1751, was never called. Nobody suggested he should have been. Miss Reeves, who was the midwife attending the claimant's mother, who gave some evidence about this, which my lady will have seen, was never asked about it. There are 80 pages of her transcript. She wasn't asked a single question about Miss Nix's whereabouts. Nobody asked Miss Nix whether she was on the phone, whether she was engaged in a conversation which might have impeded her ability to...
I understand this point, but I wonder whether you're aiming at the right target. Clearly, no claim in negligence could possibly succeed on the basis of the performance of Miss Nix. Far from it. The case against you wasn't being run on the basis that Miss Nix dragged her feet or anything of the kind. On the contrary, she appears to have reacted virtually instantaneously to the crisis that was there. The case against you was being run on the fact that you hadn't hooked up the machine.
Yes,
And so the shift in the time, as it seems to me at least, doesn't have anything to do with Miss Nix's alacrity or professionalism. It's to do with the fact she wasn't given the opportunity to have acted in the way that she would have done had she not been put in this situation.
My lord, I accept entirely that Miss Nix's location and ability to hear between 1750 and 1751 had nothing to do with the breach of duty case at all. I accept that. But it was, as it is now formulated, absolutely central to the factual causation case that was being run. Because the factual causation case, as it's now being put, is that because of your negligence in not having the CTG up and running, Miss Nix was deprived of 60 seconds in which she could have intervened, yes, which she didn't. And so that being the factual causation case makes it absolutely central to the claim the claimant is now seeking to run, my respectful submission, for the first time on appeal, absolutely central to identify where she was, what she could have heard, and so on.
Well, you know that she was there at 1750.
Yes.
And you know what she could have heard at... We know what she did hear at 1751, which is the first time that the sound came on.
Well, my lord, that supposes, in my submission, what was never established and what, in my submission, the judge never found, which is that she was standing static for 60 seconds outside the room in circumstances where she might have heard a bradycardia running if there was a CTG hooked up. The judge didn't find that. He found precisely the opposite. He found she went in at the same time she would have done in any event. She arrived outside the...
Sorry, that's a consequential finding based upon the evidence which is now under discussion. But I mean, you will know the detail of the evidence, but I have the image that she's standing outside the room making up her notes.
Well, my lord, the judge didn't find that.
No, but was that her evidence?
Well, my lord, can I in that case take you to the evidence? Well, the short answer is no.
Oh, right, okay.
The short answer is her evidence was, I arrived outside the room, I heard the bradycardia, and I went straight into action.
And what did she say about her note-taking?
Well, very little, my lord, because I don't recall anybody asking her about it, other than the question I asked, which was, can you help with why your note at 1750 is below one timed at 1753? And she said, no, I'm afraid I can't. But what she never said, nobody ever asked her, and certainly the judge never found, was that she was standing in precisely the position that she was in when she did intervene for 60 seconds prior to that. Because that was never a proposition that was being advanced by anybody at trial. And so when the judge found, as he did, at 297, I find as a fact on all the evidence that she went in at the same time she would have done in any event. That was not
But that's not the whole of the finding. The finding starts with the fact that she was standing outside the room at 17:50. So we do know where she was. Whether she was writing at the time or not, it looks quite plausible she was writing, because she wrote a note that was timed at 17:50. And it has every sign of a note that was interrupted by more important things. So I'm not quite following that.
Well, my lord, the point is what he then says next. I find as a fact she was standing outside mother's room on the labour ward at 17:50, and so on the but-for scenario, plainly correct factual premise, on the but-for scenario, she would probably, again factual, have walked into the room at the same time she did anyway. And the debate is whether or not that is a finding he was entitled to reach on all of the evidence. And in my submission, it plainly was, because he did not find, he was not invited to find, and there was not sufficient evidence for him to find that there was, as is now being put, a 60-second period where she was standing outside doing something else in circumstances where she might have heard a bradycardia. He did not find that. And insofar as my learned friend seeks to construct that minute of inaction, not blameworthy inaction, but
yes,
inaction.
it's not inaction, she's writing a note. There's nothing happening that would cause her to do anything else.
Yes, I don't mean that pejoratively,
No.
my lord. But insofar as my learned friend seeks to construct 60 seconds of potential for action,
If the scan thing had been,
if the scan thing had been run, that was not a finding that the judge reached, and he was entitled not to reach. And I will take, my lords, my lady, to the factual evidence that goes to this in just a moment, because the detail is important. But the submission I wanted to make at the outset, given the way that the case is now put, is that 60-second period that we are now debating was not a debate that was engaged in front of the judge. Because a 1 minute saving of time based upon Miss Nix jumping into action a minute earlier was not the case that was put, ever. Now, can I attempt to go to the evidence to make that submission good in relation to the detail? But before I do, could I just make one final observation on timings, which I anticipate the court will have picked up, but is important, my submission. My learned friend has helpfully set out a series of timings in her note, to which I take no objection. But it is apparent that when one goes to the relevant paragraphs in the evidence or the judgment from which these are drawn, they are almost always prefaced by the word around. So, for example, 1752, Miss Nix entered the room is referenced to paragraph 302 of the judgment. In real life, so sorry. In real life, the emergency occurred just as Em was arriving on the labour ward at around 17:49 hours, as I so find.
This paragraphs.
I'm so sorry.
No, it's not.
I've given you the wrong reference. That was a reference I wanted to give you for 1749.
Yeah.
The reference for 1752 is page 61.
so you say page 60.
I don't think it is.
Sorry, page 61 of the supplementary bundle.
Thank you.
I'm so sorry.
So this is her second statement, isn't it?
This is her second statement, which, as my lady's already observed, bears a strong resemblance to her first statement given during the course of the trust investigation. That statement having been made about 7 weeks after the event. And here at paragraph 4, first of all, I was doing my routine ward round on the labour ward, and at around 17:50, I arrived outside the room where Claimant's mother had been transferred to. From recollection, I heard what appeared to be a bradycardia, so I entered the room. I entered the room at around 17:52 to assess. CTG was started, and I heard what I suspected was a peak bradycardia. In review of the records, etc. Now, the other reference for the purposes of the approximate nature of the timings that may be relevant, particularly given the focus on 1751 and 1750, is in the contemporaneous records at page 90 in the same supplementary bundle. Now, on page 90 in the midwifery notes, you'll see a time of 1750, 2 entries up from the bottom. Transfer to delivery suite, care handed over to midwife Bond, written by someone else. And then Miss Bond makes a note, introductions made, claimant's mother in a lot of pain, Entonox provided. So that's at 1751. Then over the page that my lord took my learned friend to, albeit in a different place in the bundle, we have Miss Bond's note at 1753, above the note of Miss Nix at 1750. Now, given that we are now debating, as I respectfully submit, for the first time in anything like this level of care and detail, the precise sequence of events, in particular involving Miss Nix between 1750 and 1751, which includes evidence that Miss Nix was talking to midwife Bond before she went into the room on the judge's findings. That is a difficult sequence of notes to follow, or a difficult sequence of timings to follow. The net effect of that, my lords, my lady, is that when it comes to asking oneself the question, did the judge fall into Henderson-Foxworth error in reaching the finding that he reached at paragraph 297, namely having heard everything, I think she would have come into the room at the same time as she in fact did. The answer is plainly yes, he was entitled, because he had a confusing evidential picture as far as the contemporaneous records were concerned. He had yawning gaps in the factual evidence because no one thought that it was necessary to call the relevant individuals. And he had Miss Nix giving a witness statement, which I've just referred, which at least implies, she was never tested on it, but at least implies that she arrived outside the room and went straight into action. And so of course, in my respectful submission, it is a finding he was entitled to reach. Now, the final preliminary point I just wanted to make before, as I say, picking up the analysis in my skeleton, was that it is important not to, in my respectful submission, mix up different parts of the judgment and to properly identify what the judge is doing where. Now, my learned friend, for example, placed considerable weight on paragraph 98 of the judgment, which is in a section in which the judge is doing no more or less than summarising the evidence of Miss Nix. It's page 144 of the core bundle. Paragraph 98 was cited to the court, and you'll see that it's essentially just a summary of what we have just looked at. There are no findings of fact being made in 97, 98, 99. This is just a summary of evidence. Similarly, whilst I accept, of course, that paragraph 141, to which my learned friend also pays very considerable attention, is under a section of the judgment headed findings of fact. I accept that. see paragraph 126. These are findings that are simply being recorded by the judge from the general run of evidence he's heard. They are not being applied to the issue of factual causation, which he expressly turns his mind to at paragraph 283, where he says, importantly in my submission, I make the following findings of fact in relation to factual causation based on all of the evidence put before me and on the balance of probabilities. I'll come in due course to the law about not reading first instance judgments as statutes or construing them as contracts. The important point for present purposes is that the judge has explained precisely what it is he is doing in paragraphs 283 onwards. And he is making very clear that he is making those findings of fact which are relevant to his analysis of factual causation. And insofar as he may have made findings or given timings at some earlier stage of the judgment for a different purpose in circumstances where he was never being asked to do the exercise it is now being said he failed to do and identify precisely who was where in precisely which choreography between 1750 and 1751, cannot then be used to impugn the findings of fact he makes when he turns his mind to the issue with which we are concerned. And so those were my three preliminary points. Number one, the judge was never asked to do what what this court is now being asked to do in terms of making findings about who was where in 1750 and 1751. Secondly, the timings were approximate in any event. And thirdly, one should not use findings made in other parts of the judgment to undermine or impugn the part of the judgment that is relevant for the purposes of the issue with which we're concerned. And my lord, I wonder if that might be a convenient moment to break,
Certainly is.
having made those 3 points.
We'll start again at 2 o'clock.
All right.